Pleadings are the forms that are used to petition a court to dissolve a marriage. Notice is required to give the other side, but also the court, an idea of what is to be tried at a final trial. When you file a petition for divorce, you should base your petition based on a reasonable inquiry as to the facts for which you allege or the basis to dissolve the relationship, but also as to your fair share of the marital property, and then what you would ask the court to do in regards to any children of the marriage. There are several types of discovery levels that also must be pled. You have discovery level 1, 2, and 3, depending on the size of your estate and how many children you have. That will govern the discovery level in which you would ask the court to have applied in your case. An associate judge in most of the bigger Texas counties, there will be both a presiding judge and an associate judge. The presiding judge is the elected judge. The associate judge is a hired judge to assist with the volume of cases for which that county may have. You have a right for final trial to object to the assignment of the case to the associate judge, but you must file an objection in writing. The parties to the case should be stated in the divorce petition, which are generally a husband and a wife, or in a same-sex relationship, two spouses. And then if there are third parties who perhaps are business partners for which you have allegations of fraud, you should name those individuals as well and attempt to enjoin them in the divorce if they are necessary parties. Your domicile is a primary consideration in filing your suit for divorce, as the county in which you reside should be the county in which you file. In Texas, your residency requirements are 6 months in the state and 90 days in the county. These cannot be waived. Thus, if you file a case in the wrong county, it's subject to dismissal, or sometimes you can transfer the venue to the proper county, or as a third option, the court may abate your case while you reside in the county to meet the statutory requirements, for which you'll have to file an amended petition. Once you meet the statutory requirements, then you may be able to go forward. Service of the petition is notice to the other side. So filing a petition does not automatically generate service. Either you need to pay a fee to have a process server or a constable serve your divorce petition, or in the alternative, you can have the other side sign a waiver of service and file that with the court, so to ensure the other side has had notice of the claims that you brought against them. A protective order statement must also be part of the petition, which states whether or not a protective order under either the criminal code or the family code, Title IV, has been brought by either party. The dates of the marriage and separation, this is very important, as if you are alleging an informal marriage, a common law marriage, a putative marriage, and then for characterization of property, you'll need to have a date. And also for the children, as a child born prior to the marriage, you may not have the husband as a presumed father. Many times judges will want acknowledgments of paternities or DNA test if the parties were together as boyfriend and girlfriend and had children together, and then married when the child was perhaps 4 or 5 years old. Your grounds for divorce, the petition must state the grounds on which a party seeks divorce. The various grounds are contained in Section 6402 of the Texas Family Code. And those grounds for divorce include no-fault divorce, which is the marriage has become insupportable because of a discord or conflict of personalities between the parties that destroys the legitimate ends of the marriage relationship and prevents any chance of reasonable expectation that the parties would reconcile. Cruel treatment towards the other party. Adultery. Since the date of the marriage, one of the parties has been convicted of a felony and has been in prison for at least 1 year. One of the spouses has left the other spouse with the intention of abandonment and remained away for at least a year. You lived apart for at least 3 years, or one of the parties has been confined to a mental hospital for at least 3 years, and that the mental disorder is of such a degree that the nature of that mental impairment is that that person will never return to capacity. Children of the marriage. Any children born or adopted during the marriage, regardless of who the father is, should be, as to the woman, any children born of the woman must be stated in the petition, and you are required to adjudicate paternity of children who are born during the marriage, even if husband is not the father. Now, the one exception that you can not adjudicate children is if those children don't reside in Texas, and then you can plead to the court that there is no jurisdiction over those children because they do not reside in Texas. And then if you've went to the Attorney General and you've already set up a child support order, or if you've done a separate private of action with that child in a SAPSER case, suit affecting parent-child relationship, then you've already addressed it and you need not address it again. The relief you're requesting in regards to the children, whether or not you're asking to be a sole possessory or a joint managing conservator, what type of rights and duties you're asking to be allocated between the parents, and then child support. If you're asking for statutory guidelines or above guideline child support, you would need to plead for that, and you need to state to the court how you would like those rights allocated, how you would like child support to be ordered by the court, and then what possession and access you would request each parent have. Relief related to the marital property. If you have a fault-based divorce, that is typically grounds to ask for more in regards to this estate. But then if you are a traditional stay-at-home parent, and then the other parent is a breadwinner, you can ask for a disproportionate share based on your being the homemaker and the other spouse being the breadwinner. Other relief that you would necessarily want to request or may request should you expect a prolonged divorce would be temporary orders. Temporary orders preserve the status quo at the beginning of the divorce. You generally want to set up some rules, as many times when a relationship dissolves, people start to hoard or hide monies, and then assets start to be liquidated, and the preservation of the estate is important. Also, you have insurance. Many times people will cancel someone else's health insurance. They'll terminate cell phone contracts that are joint held, cause someone else to lose their cell phone number. And then auto insurance many times is shared. You'll want to set up those rules so that way there is a consequence if you were to cancel those joint, whether it's insurance or it's accounts that you may have with your spouse. In regards to the property, if you should have a claim for what's called reimbursement, or you suspect that there is fraud in the relationship, to the extent that someone spent money on a paramour, that is considered constructive fraud. So if husband has a girlfriend and girlfriend he has taken to Las Vegas and he has bought that girlfriend plane tickets and he has accommodated her at a hotel and taken her to dinner, you can ask for an accounting, and that is considered fraud, and you can ask that the community estate be reconstituted to account for that fraud. Reimbursement is the easiest reimbursement claim for this presentation is the pay down of separate property mortgage. You become married and your spouse owns property prior to the marriage, and then that once you marry, the property mortgage is taken over by the community. You pay some of the mortgage on the residence. That is reducing the principal of the other party's separate property estate, and therefore you can seek a claim for reimbursement. Alter ego is where you attempt to pierce a corporation. And as you attempt to pierce a corporation, you say that the individual and the individual spouse and the corporation are one and the same. And many times corporate assets are not subject to partition because the corporation is, the assets of the corporation are owned by the corporation. Of course, if the spouse owns 100% of the corporation and the corporation was formed during the marriage, one can always argue it's community. However, there is an argument to make that the corporation is a separate entity. Depending on the timing and the other partners in the corporation, then you may have to attempt to punch the corporate shell and claim alter ego. And that usually happens where one spouse is not taking the proper deductions and not claiming as income certain expenses, using corporate income to pay for personal expenses, and that when you get audited by the IRS usually results in income to the person who has taken those monies, and then there's usually a penalty that comes with that. Any marital property agreements that you may have, whether it's a premarital or postmarital agreement, should be disclosed to the court. If you're asking for a name change, you should plead that for the court. Group health insurance, if you're asking to extend out someone's health insurance after the divorce, you should plead for that. Spousal maintenance is alimony. We call it spousal maintenance in Texas. You should also ask the court if you think you qualify for spousal support. You need to plead for that and specifically tell the court that you believe you're entitled to it. Tort claims in a divorce context are generally going to be the fraud and waste claims, which one may bring based on the spending down of the estate by one of the spouses. You owe a fiduciary duty to your spouse in the marriage context, very similar to a banker. And so you can bring claims for the spending down of the estate to a certain extent. Now, if someone goes and they spend a fair amount of money at a couple baseball games or football games, it's a little bit harder. But if they gamble, if they go to the horse track, if they do drugs, illegal drugs, and they spend a lot of money on illegal drugs, then usually you can ask for the estate to be reconstituted. Also, if you've been assaulted during your marriage by your spouse and you filed a protective order and the protective order was granted, those are personal injury claims, and you can bring those as well. Attorney's fees, if you're asking your spouse to pay your attorney's fees, and then attorney's fees on appeal are a separate pleading for which you must file. So if you're asking for attorney's fees, you have three types of attorney's fees: interim attorney's fees for final trial, and attorney's fees on appeal. I plead for all three in my cases. My name is Michael Busby. This is a presentation on divorce pleadings. If you like, please subscribe. Thank you.